All rise. The Court of Appeals, Division 1, is now in session.
Good morning. Please be seated. Morning. We are here for oral argument in our case number CV17-0675 in the matter of the Richard J. Fell Trust. As you may know, these proceedings are being recorded, so we'd be grateful if you each, as you approach the podium, would give us your name and the name of your client for purposes of that recording. Each side is allotted 20 minutes for your argument. Appellant, you may reserve any amount of time to use in rebuttal, but you're in charge of keeping track of your own time. The clock on the podium reflects the total you have remaining, including any you intend to reserve. Please keep in mind we've read the briefs, conferenced the case, we've studied the record. So with that, please proceed.
Thank you, Your Honors. May it please the Court, Al Arpad on behalf of the appellants, Ryan and Sharon Magnan and Lynn Magnan Donovan. This is an unfortunate case that probably could have been resolved in about a 30-minute hearing, and now here we are almost a year and a half later arguing about whether we should go back and have the 30-minute hearing. I'm somewhat at a loss what to argue because my clients clearly should not have been thrown out of court, but I'm not sure exactly how and why they were thrown out of court, so I've made a lot of different arguments. Any assistance you can give me by asking questions would certainly be appreciated.
Let's start with appellate jurisdiction.
Yes, Your Honor.
What do we have appellate jurisdiction over and why?
You have appellate jurisdiction over the decision to essentially enter a 54C certification on the minute entry denying the motion. There had not previously been a certification of finality in the case. Rule 4 is clear that in a trust case it ends when there's a certification of finality. You then have a post...
Let me slow you down just there. If we have jurisdiction over that order or that judgment, if you will, who properly has appealed from that judgment?
All three of my clients believe they have appealed and intended to appeal because they all three intended to file the motion together. If for some reason you find that one of them should be struck out, then I suppose the remaining ones are appealing.
And let me ask you, just as a comparative stranger to the record, and I understand that you've been retained on appeal and weren't sort of in the court at the time either. Had anyone other than Lynn appeared before that that objection or the motion to reopen was filed?
That depends on what you mean by appeared. Only Lynn had filed an appearance fee prior to that motion being filed. Ryan had actually showed up for the hearing and been appointed as the trustee, right, but nobody told him at that time, hey, you really should have filed a fee, and so he didn't.
Right. And is it your position that it was the court's obligation to tell him that, or that he was obligated to know that as someone who, if he intended to participate?
Well, typically this is taken care of, and it's one of the strange things about this case, because typically this is taken care of by the clerk not accepting your pleading if you try to file it without paying a fee. They look it up and you haven't paid it.
He had not filed anything at that point, correct?
Right. He had not filed anything at that point, and it happens very commonly in probate because the way probate works is you announce a hearing, you give notice to a lot of people, and people show up, and typically what the court does says, are you going to appear? Are you going to object? Are you going to do things? Do you have a lawyer? Okay, if you're on your own, you need to pay a fee to appear. That's what Rule 12D says, and that's what's typically done. Nobody did that in the first hearing with Ryan.
Or Sharon.
Or Sharon, and Sharon had not at that point appeared.
And in fact, okay, that's helpful. The motion to reopen, in fact, listed Ryan and Sharon, but their names were crossed out.
And that's because the clerk, as would typically happen, said, okay, the only pro per I have in this case is Lynn. And Ryan said, oh, okay, well, if I cross these names off, will you accept it? And this is all explained in his affidavits in a fair amount of detail, but he
actually explained that he didn't want to pay the appearance fee.
I don't think he was saying he didn't want to pay it. I don't think he had the cash on him at the time. But in fact, he was saying, oh, okay, if I do it this way, can I submit it? And he didn't know that would mean that he wasn't appearing.
And your position is that a trustee can appear as a self-represented party?
I believe that's true, yes, Your Honor. Certainly there's no decision or statute that I could find saying they can't. And particularly in this case, where you've got 3 co-trustees, in my view, not necessarily in the trial court's view, and you've only got 3 beneficiaries, and so every possible interest other than unborn children and so forth is actually sitting there in the court. So you haven't got the trustee appearing even arguably on behalf of someone else.
Let me ask you about that, and I don't know that it may not be germane to what we're asked here today. But as I read the filings on the motion to reopen, it purports to list 3 co-trustees. Now, we can discuss who filed it, who didn't, and the record kind of is what it is. But then the motion to reconsider for new trial, which only Ryan filed, he's listed as the trustee. Did things change somehow?
Well, no. He says in the motion and in the affidavits that are attached to it, I'm only doing this because the court told me I had to in the minute entry, but we still think we're the co-trustees and we still want to appear, so please let us appear and explain that to you. And I forgot to say I'd like to reserve a few minutes for rebuttal, but...
Please continue. You've been
sure.
Kind with your time so far.
The other slight twist on it is that these parties were filing jointly. And so there isn't actually a clear rule that I could find on what unrepresented parties can and can't do in terms of filing jointly. One of them can't file something saying, you know, I'm Ryan and therefore I'm appearing on behalf of Lynn and sign it Ryan. But whether other parties, particularly in a probate case where there could be dozens of them, can say, I agree, and does that count for anything or does it not count for anything is not at all clear. And one of the things I discovered is when I file, as I did with this appeal, a paper on behalf of 3 parties or any number of parties, I pay 1 fee. Apparently, the clerk has this policy that when 3 parties file 1 pleading, they have to pay 3 fees.
Isn't that attributed, or couldn't that be attributed, though, to the fact that you represent 3 parties and a self-represented party can represent themselves only?
I think that's the logic, but I don't see how you could put the burden on my clients to know that ahead of time. I didn't know it ahead of time, and I don't think very many people know it ahead of time. And so that's why in probate it makes sense to say, okay, if the court thinks somebody else should be paying a fee, they should tell them to pay the fee rather than throw the whole thing out of court. Because they weren't just thrown out of court for not appearing, they were thrown out of court based on some findings that were made without any evidence and contrary to the sworn affidavits that were, or the sworn declarations that were in the motion. And they were then, the court then decided that one of them who was not the trustee was really the party who was filing on behalf of the others, even though she wasn't even in Arizona, hadn't showed up and filed the papers. I mean, it's a factual situation that the court never sorted out and shouldn't have entered judgment on without sorting out.
Let me ask you, what's the authority that you rely on for a claim that someone by declaration alone can purport to be a trustee and that has to be honored?
Well, it doesn't have to be honored, but if you're going to controvert it, you have to have a hearing or something. I don't think you can say, I find as fact that you're lying when you haven't had a hearing and you've got nothing in the record to show otherwise.
Let me use a hypothetical. If one of your clients went to Bank X and said, I have a declaration that I'm a trustee of the Fell Trust, I would like to withdraw all the money, what would happen, do you think?
Typically, banks want more than that, but not always. Banks and title companies sometimes accept declarations from people, or it kind of depends how many declarations they want. Sometimes they say, no, I'm going to wait for a court order. It varies quite a bit in the real business world.
And is there a statutory basis under Arizona law for the thought that someone needs to be treated as a trustee by simply signing a declaration?
I am not aware of a statutory basis, although there are statutes that suggest that, for instance, third parties can rely on documents provided like that. But in the case of a court, I don't think the court's controlled by a statute saying you could rely on it and therefore you're protected from liability in the future. I think the court needs to find out what the real facts are if the court has concerns about it. As I briefly alluded to, I think that saying that the parties are held to the same standard as a lawyer is not an answer in this case. I want to emphasize that all the arguments we've made are not asking for special treatment. We've said that nobody should be treated this way, whether they were represented by a lawyer or not, whether their lawyer did a good or bad job. I think other than the fact that you have to deal with the rules about whether people need to pay multiple fees when they're pro per litigants, all of these arguments apply equally to everyone. And the general rule is that there should be decisions on the merits, not that there should that the rules should be made into a trap or that people can waive things without knowingly and voluntarily waiving things. Judge Albrecht, a number of years ago, wrote an article, Judicial Techniques for Cases Involving Self-Represented Litigants. And one of the things she noted in there is that sometimes just by not taking a little extra step to help pro per litigants, they are actually significantly disadvantaged. I mean, judges all the time make observations as a courtesy to counsel. For instance, let's say you have a divorce case, and this is the example she uses in her article, and the self-represented litigant fails to mention that they live in the county. The judge says, dismissed, you haven't established jurisdiction. Now, if that was counsel, the judge would probably say to counsel, counsel, have you established jurisdiction? And counsel would say, oh, right. May I bring my client back up to the stand? How long have you lived in this county? More than 6 months. Okay, now we've established jurisdiction. It kind of flies below the radar, but it becomes pretty evident in this case. I don't think if my clients had been represented by a lawyer who'd done the same thing, I don't think they would have been thrown out for filing a motion rather than a petition. I don't think they would have been thrown out based on why does this say there's 3 trustees when I said there's only 1. Those things would have been sorted out in some type of a hearing rather than simply dismissing it and entering judgment on it.
Do you read the record as the court taking exception to the form of the motion? That was a motion, not a petition? Because I read it quite differently.
I think that's more something that the bank came up with. I think that the only thing the court really said was, I think somebody here out of these 3 people is trying to represent the other one who's the real party, and I'm not going to allow it. And the court shouldn't have done that without taking evidence on it and figuring out what the real situation was. Even if it was true, which I don't think it is. They were very clear about what they were doing and saying, here's what we're trying to do. So there wasn't any sneaking around going on. But even if that were true, you would still need to deal with the proper party who's there in front of you asking for relief. Just briefly, the biggest problem here was the entry of the judgment. If the court had simply said, no, I think this is the wrong form, go back and do it over, this wouldn't be here. Because the judgment was entered, my clients had the problem of potential res judicata effect and their claim being barred. Now, I would argue that does not apply, that no decision on the merits was made here. But I can't in good conscience send my clients back and say, file a pro per petition, and then you good luck dealing with the res judicata motion that's going to come right after it. My clients essentially had to appeal in order to protect their rights to ever bring this type of claim, whether it's through a petition or a motion. The factual findings, again, it's really almost the paradigm of denying due process. The judge or the commissioner herself said, these facts are unknown, therefore I find the following. That doesn't make sense. If you'd had a hearing and it was clear who the burden was on and that person failed to prove something, then okay, you can enter a judgment at that point. But you can't do it without having a hearing, and you particularly can't do it when there are declarations attached that, at least for purposes of pleading and for purposes of a prima facie case, establish their standing to do what they say they're trying to do. And by the way, the court already knew they were beneficiaries, and they would have had standing to do it as beneficiaries, too. So it didn't come up until later that the bank denied that anybody was even a beneficiary, or denied that Lynn and Sharon were beneficiaries. Unless you have further questions, I think I'll reserve the rest of my time because I'm not really sure what the bank is going to focus on. Thank you.
Good morning. It seems to me one of the big problems here is that they still feel that they have a case that there's co-trustees.
Counsel, for purposes of the record, could you introduce yourself and your client, please?
Sure, Your Honor. This is Roger Curley, and I represent the Bank of Arizona, which in the appeals papers is listed as BOKF. And they were the prior trustee of the Richard Fell Trust. And what happened is, yes, we had a proceeding, a petition was brought to decant. There was talk, I'm sure you've seen the transcript of the hearing, and at the hearing it was decided that, well, we don't have to decide the decant. The court says, well, I don't have to reach that issue because we're just going to have Ryan appointed as successor trustee, and the bank is hereby terminated, and the bank is to turn over all the assets of the Richard Fell Trust to Ryan. And that's what the court ordered. The court also specifically denied the request to have Lynn and Sharon appointed as trustee. That was also requested by Lynn, and the court denied that. So the only person appointed trustee was Ryan. And later on, they tried to claim that they somehow had some meeting or something, or had something done to have Lynn and Sharon appointed trustee. The difficulty with that is the order appointing Ryan didn't allow other trustees to be appointed. The trust agreement does not allow any other person to be appointed trustee. There's nothing in the document that says, yes, the beneficiaries can get together and appoint co-trustees. It doesn't allow that.
Does Arizona law allow that?
Arizona law does not. There is a rule, which was finally cited by my co-counsel, the counsel in the reply, which states that if there is a vacancy, then the qualified beneficiaries can appoint a trustee. And that's how Bank of Arizona got on, because there was a vacancy and the qualified beneficiaries were then, under our rules, able to appoint. I shouldn't say rules, it's a statute. It's ARS 10704, paragraph C. And that statute says, yes, if there is a vacancy, the qualified beneficiaries can appoint. That's how the bank got on. But there wasn't a vacancy here.
How do we know that?
Pardon?
How do we know that?
Because Ryan was still the trustee. Nobody removed him.
How do we know that Ryan didn't step aside and then agree that he and the other, and then Sharon and Lynn would become trustees?
We know that because in the papers that were filed, it says Ryan as co-trustee. If he wasn't, why would he call himself a co-trustee?
Well, my question, though, was what if he stepped aside as trustee and then the three agreed that they all would be co-trustees? Isn't that another plausible explanation? I mean, we take.
I mean, I guess you could make things up, but no, that was never alleged.
I don't think that's making it up. I think that's one way to view the record we're presented. And remember, and again, I know the argument that this should have been a petition as opposed to a motion, but we're effectively to get to the resolution that the bank would suggest. We're effectively being asked to go behind the pleadings, if you will, and that's not typically what we do.
Well, no, I don't think you have to go behind the pleadings. I think you look at the pleadings. Nothing in any of the pleadings says that Ryan resigned.
Correct.
So there's no even allegation of that.
But the pleadings with declarations for two of the three, I don't think for Sharon, but for two of the three, he says we're co-trustees.
I understand, but that's the thing. They just can't come in and declare themselves co-trustees.
Well, I understood you to say that the statute that you mentioned would allow if there's a vacancy.
If there's a vacancy, and there wasn't a vacancy.
Well, how do we know there wasn't a vacancy?
Because nobody ever in any of the pleadings have alleged that Ryan stopped being trustee.
But he alleges he's co-trustee and
He says he was a co-trustee because he thought that Sharon and Lynn were co-trustees, but they weren't.
Even though they declare under oath.
I have no doubt that Sharon and Lynn thought they were co-trustees because all they had to do was have this meeting, because this is what the bank did, and all they had to do was have something in which the three of them sat down and agreed that they were all trustees. But no, that's not the way it works.
Well, and I understand that this is atypical in many ways, but effectively what you're asking us to conclude is that it was impossible. And help me better understand why it was impossible that they were co-trustees.
I'm not saying it was impossible. They could have gone to court and asked to be appointed co-trustees.
But
That would have been easy enough.
The statute doesn't require court action, does it?
Again, the statute requires a vacancy.
Correct.
There was no vacancy
How do we know that?
because nobody ever alleged that Ryan stopped being trustee. The court had nothing in front of it saying that, oh, Ryan stopped being trustee, and so therefore we had to get together under the statute to appoint new trustees. No. There's nothing in the record. No, they just thought we could just have a meeting and name whoever we wanted because that's what the bank did. Well, the bank did it because there wasn't any trustee. Nobody's denying that.
Do you think it was perhaps incumbent on the court to take some evidence on all of that to kind of flesh out what the sequence of events were? I sense that that's the tenor behind Judge Thumb's questions.
Yeah, and the thing is, no. Because based upon what it had in front of it, its determination that Ryan is still the only trustee was supported by what the court had. The court knew that it had appointed Ryan. It saw nothing that caused Ryan to stop being a trustee. And the court knew that under the law and under the document, people can't just come in and declare themselves co-trustees. And so the court properly made the ruling based upon what was before it. It didn't need any other evidence that Ryan was the sole trustee. And so therefore, Lynn couldn't represent Ryan, and therefore the motion to reopen was wrongfully filed. And this is not depriving anybody of due process rights. Ryan, at any time, all he had to do, and the court had even instructed him in the original, in the transcript, if you read it, is that she says is that, hey, you're being appointed the trustee, and the statute of limitations is running, and if you want to bring something, you got to bring a proceeding. How do you bring a proceeding? You bring it by petition. He could have, at any time, brought a petition to surcharge the trustee. At any time.
Including tomorrow.
Including tomorrow. Including today. He could be filing it right now. There's nothing that stops him from doing it. Now, Lynn and Sharon can't do it because they have no interest in this trust anymore. They're not beneficiaries anymore. They stopped being beneficiaries as soon as Ryan got to be 30 years of age, which happened in November of 2017. So they have no beneficial interest in this. And I think the court rightfully found that they aren't trustees anyway, either. So no, they have no right to bring a proceeding. Even today, they have no right to bring a proceeding. Can Ryan? Yeah. Now, that doesn't mean the statute of limitations against Ryan may have run. That's a different issue. But that's his problem in not proceeding in a timely fashion. And the court warned him of that, that he should proceed in a timely fashion. So unless your honors have any other questions, I think that's the essence of the case here. Thank you.
I think your honors understand this was an unsupervised trust, and so there was no limitation on the party's abilities to deal with it as an ordinary trustee or beneficiaries would do without the intervention of the court. The bank's pretty much entire argument that they've just made on you turns on a rather technical interpretation of a statute saying that no trustee can be appointed apparently outside of court unless there's a vacancy in the trusteeship. I'm not aware of that being a general principle of trust law. In fact, trusts are extremely flexible. You can have trustees appointed all kinds of ways, and in fact, you can have constructive trustees. You can have very, very informal ways of trustees accepting trustee duties, and in fact, it's the acceptance of the duties of the trustees. I think we've cited you that statute. I don't remember the number off the top of my head. That is the operative time when the trustee becomes a trustee. I think you will be making new law if this case turns on that technical distinction. The critical thing, if you follow Mr. Curley's logic, he admits now that Ryan could go back and bring a petition, essentially the same document, I suppose, saying petition at the top instead of motion. He probably has to pay some additional fees for that if he does that. That there would be nothing to stop him from doing that. If you follow that logic, which I don't think you should, it is important to emphasize that the supposed factual findings and so forth that were in those minute entries are not res judicata, and that the court did not decide these issues on the merits when it dismissed them. A dismissal is on the merits if it's because the person has no claim. A dismissal is not on the merits if it's because the right person didn't properly appear. But the reason that I'll urge you to send this back in the posture it was in before is because this is, at its essence, an attorney fee dispute. An attorney fee dispute about the attorney fees incurred in the first proceeding. And it's something that normally would be handled in the same case. It's not something that you normally have to go file a petition for relief on. And it's something that the court specifically had denied relief to the bank on in its petition. The bank requested a release of liability. It was at least a purpose, and I would argue the major purpose of the whole petition in the first place. The judge said no, and at that time left that proceeding open. And there's no question, legally, that proceeding was left open because there was no 54C determination. It's completely consistent with what the judge said in the hearing, is that you, Ryan, you have these responsibilities. You need to take care of these things. Be sure you take care of these things. That issue was properly before the court based on the pleadings. And so throwing it out and making them start over doesn't make a lot of sense to me. It involves a bunch of additional costs, and I don't think it's what would happen if an attorney had been appearing in this case and had asked for the same relief at the end of the case when the prior petition was still open and when such a motion could properly be made. That's really all I have for you, unless you have other questions for me.
Thank you, counsel.
Thank you.
Thank you both for your arguments. We'll take this matter under advisement. The court will be in brief recess while we prepare for the next argument. Thank you.